Whistleblowing is a critical mechanism for ensuring transparency and accountability within organizations. Companies that embrace whistleblower protections foster trust, improve workplace morale, and safeguard their reputation. The EU Directive, EU 2019-1937, highlights the importance of corporate responsibility in creating environments where employees can report misconduct without fear of retaliation. Protecting whistleblowers is not just a legal obligation, it's a strategic priority. When companies encourage employees to speak out, they gain insight into operational weaknesses and can address issues before they escalate into public scandals. Directive EU 2019-1937 requires companies to establish robust internal reporting channels to protect whistleblowers from retaliation and ensure fair handling of disclosures. Companies must implement confidential, user-friendly mechanisms for employees to report concerns. These systems should allow for anonymous reporting to ensure that employees feel safe. Employees should be aware of how and where to report concerns. Regular training sessions ensure staff understand the importance of whistleblowing and their role in maintaining corporate integrity. Leaders must demonstrate a commitment to ethical practices by acting on whistleblower reports swiftly and effectively. Failing to address whistleblowing effectively can have severe consequences for companies, including reputational damage, legal penalties, and financial losses. On the other hand, a well-implemented whistleblower policy offers numerous benefits. Early identification of potential misconduct allows companies to take corrective actions before regulatory bodies or media attention. Organizations that prioritize transparency are more attractive to employees, investors, and customers. Companies that meet or exceed the standards outlined in the EU Directive avoid penalties and improve their legal standing. The LuxLeaks case revealed how a lack of whistleblower protections can lead to public outrage and reputational harm. Companies implicated in the scandal faced intense scrutiny, highlighting the importance of addressing internal concerns proactively. The Cambridge Analytica revelations exposed how unethical practices in data usage can damage trust and lead to regulatory action. Companies must ensure compliance with data protection laws, such as GDPR, to avoid similar fallout. Volkswagen's emissions scandal demonstrated how ignoring employee concerns can lead to devastating consequences. Transparent and supportive internal reporting mechanisms might have prevented the crisis. To effectively integrate whistleblower protections into corporate practices, companies should focus on the following. Senior management must champion whistleblower protections, setting the tone for the entire organization. Whistleblower reports should be addressed promptly, with thorough investigations and appropriate follow-up actions. Companies must enforce strict anti-retaliation measures to protect employees who come forward. Fear of reprisal discourages whistleblowing and erodes trust. As businesses evolve, so must their whistleblower policies. Regular audits ensure alignment with legal requirements and industry standards. As technology advances, whistleblowing systems must adapt. Companies should invest in secure digital platforms for reporting, ensuring anonymity and protection in the digital age. Furthermore, integrating whistleblower protections into ESG, environmental, social, and governance, strategies will become increasingly critical as stakeholders prioritize ethical business practices. Whistleblowing is more than a compliance issue. It's a foundation for ethical and sustainable business practices. By protecting whistleblowers, companies not only uphold legal standards, but also build a culture of trust, transparency, and accountability. The companies that lead in this area will not only navigate challenges more effectively, but also position themselves as leaders in corporate integrity.